steps of the IRAC method of legal analysis to give you a better understanding and perhaps make your approach to legal analysis a little easier. Several of the ideas and concepts in this lecture are drawn from our textbook, Legal Analysis and Writing, 3rd edition, by William H. Putman. Step 1 of the IRAC method is to identify the issue or issues raised by the facts of the client's case. The issue is the legal question raised by the facts of the case. Remember, a single set of facts may contain multiple issues. When that's the case, you should separate the issues and analyze each of them individually. Step 2 of the IRAC method is to identify the rule of law that governs the issue. This is where legal research comes in. You'll need to research the law to determine the rule of law that governs your issue or issues. The rule of law that applies to your issues may be enacted law, such as statutes, ordinances, regulations. It may be case law, or it may be a combination of enacted law and case law. Step 3 of the IRAC method is the analysis or the application part. In step 3, you'll determine how the rule of law applies to the issue. There are 3 subparts to the analysis or the application step of the IRAC method. First, you must identify the elements of the rule of law. Second, you must apply the elements of the rule of law to the facts of the client's case. You must consider each element of the rule of law to determine if the facts of the client's case can satisfy each element. Third, you should consider any potential counter-analysis or counter-argument to the analysis. In other words, at this point, you should be thinking in terms of what arguments your opponent may raise with regard to how the facts apply to the elements of the rule of law. The final step of the IRAC method is the conclusion. This